Good morning, everybody. Thank you for joining us. My name is Amber Hines, and I am super excited about having attorney Stephanie Prestridge with us today to talk about InMarriage QDRO. We're going to kind of split up today's webinar. I'm going to start out talking about qualified accounts, name on the check rule, and then I'm going to turn things over to Stephanie to discuss InMarriage QDRO. I hope everybody is doing well today, staying healthy. I want to let you know that the handouts for today's webinar are on the GoToMeeting dashboard, so you can find a copy of the handouts. If you have questions throughout the webinar, feel free to post those in the GoToWebinar dashboard under the questions section. We'll leave some time at the end of today's webinar to answer any questions that you have. Again, my name is Amber Hines. I've been working with elder law and estate planning attorneys for the last 15 years on Medicaid compliant annuities. I'm a licensed insurance agent in all 50 states, and I also hold my Series 65 license with FINRA. I created Ashford to assist attorneys and advisors with Medicaid compliant annuities from A-rated insurance carriers. So I'm only working with A-rated carriers when I am placing Medicaid annuities or hybrid long-term care insurance policies. We're going to start out with some basic information about Medicaid asset and income eligibility requirements. From an asset standpoint, when we're trying to qualify a couple for Medicaid, usually the institutionalized individual or the Medicaid applicant is allowed to keep $2,000. This is going to vary by state, but this is the most common amount that the institutionalized person is able to keep. The community spouse, on the other hand, or the well spouse, the spouse that remains in the community, is generally able to keep 1/2 of the spousal resources up to $128,640. Again, this is going to vary by state, but this is going to be the most common maximum amount that the community spouse is entitled to. From an income standpoint, when we're dealing with a married couple, the institutionalized spouse, their income must be less than their cost of care. This really isn't that hard to achieve when we look at the cost of care being anywhere from $5,000 up to $20,000 per month. Most clients don't have enough income to pay for their cost of care, so meeting this requirement of the institutionalized person's income being less than the cost of care is not a hard thing to achieve. There are some states that will impose an income cap, and in those states we'll be looking at doing a qualified income trust or a Miller trust to get the person's income under the maximum amount in that state. The community spouse, on the other hand, is entitled to unlimited monthly income. There are 2 states right now, Illinois and New York, that if the total income of the community spouse exceeds a certain amount, then there may be a spousal support order that is required that will require the community spouse to contribute some of their income to the institutionalized person's care, but that is only currently an issue in 2 states. If we're looking at spending a client down in Medicaid crisis planning, we're talking about spending a person down when they have excess resources over the $2,000 or the $128,000 that we just mentioned on the last slide. The goal is to convert countable resources into non-countable or exempt assets. This can be pretty easily achieved when we're talking about clients that have checking, savings, or CDs at a local bank. We're not concerned in that scenario with any tax consequences because those are all after-tax accounts or they're not pre-tax retirement accounts. Medicaid crisis planning in that scenario is going to be pretty easy because we can have the client just go down to a local bank and get a check to convert countable assets into non-countable. They can purchase prepaid burial plans. They can purchase a Medicaid compliant annuity. They could do a promissory note. There's a lot of different ways that we can convert countable assets into non-countable assets when we're talking about post-tax dollars or non-qualified accounts. Planning is going to become a lot more difficult when we're dealing with qualified or pre-tax accounts. The reason why it becomes more difficult is because now we have to be concerned about the tax consequences of liquidating a pre-tax account because those monies have never been taxed before. We cannot simply just change ownership on a qualified account from husband to wife or wife to husband without triggering a taxable event. So manipulating qualified accounts or transferring ownership on a qualified account is going to result in your client paying taxes when they do so. If we look at what qualified accounts are, we're generally talking about an individual retirement account or an IRA. This is an account that maintains special rules under the IRS that will allow the client to avoid income tax until retirement age. Qualified accounts or IRAs are pre-tax accounts, meaning that this money has never been taxed before. So once the money is withdrawn, ownership is changed, or we annuitize that account, then at that point, tax consequences are going to be triggered on those accounts. Tax laws impose a special financial penalty for early withdrawals of an IRA sooner than 59 and a half, but this does not necessarily prevent Medicaid from considering the account to be a accountable resource. So this is an example of Medicaid and IRS rules not necessarily jiving when we're talking about getting a person eligible for Medicaid. So just because the person is under 59 and a half and they would have additional penalties for liquidating that account does not necessarily mean that Medicaid is going to consider that to be an exempt resource. Other types of qualified accounts aside from an IRA can include 401ks, 457, a thrift savings plan, a 403b, a SEP plan, or a simple plan. These are all going to be pre-tax accounts that will have tax consequences if we were to just liquidate or transfer ownership of those accounts. Medicaid planning and qualified accounts, each state is going to be different as far as how IRAs or qualified accounts are treated for Medicaid planning purposes. States are going to take one of the three following positions. They can either completely exempt the IRA and consider them to be non-countable. They can consider the IRA to be exempt if the person is receiving their required minimum distribution or regular systematic payments. So if they're over the age of 72, or they can completely count the IRA as a countable resource or accountable asset. This may be different for a community spouse and an institutionalized spouse. So for example, Pennsylvania and Wisconsin are two states that will exempt the qualified account of the community spouse, but they count the institutionalized spouse's qualified account as accountable resource. If you're unsure of how your state considers these qualified accounts to be countable or non-countable, just shoot us an email or give us a call and we'd be happy to help answer that question for you. States where the qualified accounts are exempt. If you practice in a state that completely exempts the qualified accounts of the institutionalized spouse and the community spouse, this is going to make planning pretty easy. There's not really a need to do any Medicaid spend down planning for that qualified account if the account is non-countable or exempt. There are currently only two states that completely exempt the institutionalized and the community spouse's qualified accounts. So there's not many that will allow for the person to have a large qualified account without counting that to be a countable resource that we have to plan for. Other states where qualified accounts are exempt if the person is receiving their required minimum distribution, this can be a pretty easy planning strategy in states where we have a person that has a qualified account where the state says that the qualified account is exempt if they're receiving their required minimum distribution. Currently under the Secure Act, the RMD age is age 72. So if you have a client that has a qualified account and we put that into RMD status or systematic payment mode, then that is going to make the account non-countable, and it's only going to consider the income to be countable income in that scenario. There's only 9 states that treat qualified accounts this way, where they consider the account to be exempt if the person is receiving their RMDs. Planning is most complicated in states where we consider the qualified accounts owned by the institutionalized spouse to be an available or accountable resource. Most of the country treats qualified accounts this way. There's 40 states currently that consider the institutionalized spouse's qualified account to be an available resource that we would need to plan with. On this slide, you're seeing a copy of, you're seeing a map that has all of the states in white that consider the institutionalized spouse's qualified account to be an available resource. All of the states that you're seeing in orange are states that either consider the institutionalized spouse's qualified account to be unavailable, completely exempt, or unavailable if the person is receiving their required minimum distribution. So we're really focused on the states here that are in white that are going to consider the qualified account to be accountable resource that we need to plan with. What is name on the check rule? This is a Medicaid concept that stands for the idea that income belongs to the person whose name is on the check. It can be found in 42 U.S. Code section 1396. Something to keep in mind is that this is not an IRS rule. It is nowhere found in the IRS rules or regulations allowing for us to dictate that the institutionalized spouse can direct payments to the community spouse when we have a qualified account. The rule is used when we have a married couple situation where the institutionalized spouse owns a qualified account or an IRA account that must be spent down in order to gain Medicaid eligibility. As you may recall, in most states, the institutionalized person is only entitled to $2,000 or less of resources. So we are going to use name on the check rule in situations where the institutionalized spouse has a qualified account that exceeds the $2,000 threshold that the institutionalized spouse can keep. We're going to consider a case study of Joe and Mary. In this scenario, Joe is 78 years of age, and after struggling with dementia for years, he is now in need of nursing home care. Joe's monthly income is $1,500. His monthly nursing home bill is $10,000 per month. And Mary is his 76-year-old community spouse who has monthly income of $800. And her monthly maintenance needs allowance each month is currently at the minimum amount of $2,114 per month. Together, the couple owns a home, car, prepaid burials, and $350,000 of countable resources. And of the $350,000, $250,000 consists of Joe's qualified retirement account. First, we're going to determine what the spend down amount is, or how many resources we need to convert into non-countable resources. So Joe, as the institutionalized spouse, is able to keep his personal property, a prepaid burial policy, and $2,000 of the $350,000. Mary, the community spouse, is able to keep the home, car, her personal property, a prepaid burial plan, and $128,640 of the $350,000. If we deduct the $130,640 from the $350,000 of total resources, we find that the spend down amount in this case is $219,360. The real problem asset in this case is Joe's qualified account. So if we're working in a state that the qualified account is accountable resource, we're trying to figure out what is the best way to spend down Joe's retirement account in the most cost-effective, tax-efficient way while also achieving Medicaid eligibility for Joe as quickly as possible. The options in this case, number one, we could do nothing at all, and this couple could privately pay until Joe is eligible for Medicaid by getting down to the allowable asset limitations. If the couple just continues to privately pay at $10,000 per month for Joe's care, we know that they're going to exhaust the IRA value of $250,000 within 2 years of privately paying based on the fact that they're paying $10,000 per month. The second option is we could liquidate the institutionalized spouse's qualified account and transfer the net proceeds over to Mary, to the community spouse, but the couple is going to pay all of the taxes up front. So if we assume that they're paying around 24% in taxes, then they're going to lose around $60,000 up front by just liquidating the institutionalized spouse's qualified account and transferring the proceeds over to the community spouse. We know that there aren't any transfer penalties for transferring assets in between spouses, so is not a penalized transfer for Medicaid qualification purposes, but it may not be the best thing to do from a tax standpoint if we're talking about paying all the taxes up front and then transferring a net amount over to the community spouse. The third option would be to convert the institutionalized spouse's qualified account into a tax qualified Medicaid compliant annuity. In this scenario, we're able to convert accountable resource, or the $250,000 qualified account, and turn that into an income stream. And we could name Joe as the payee on that contract, and we would still obtain immediate Medicaid eligibility, but we may not want to do that if we're not going to get a shifting of income under the MIMNA rules over to Mary as the community spouse. So that's where option number 4, using name on the check rule, is going to come into play, where we can name Mary as the payee on the Medicaid compliant annuity. The fifth option, which Stephanie is going to talk about, is to implement InMarriage QDRO. So we're going to first talk about option number 4, name on the check rule. Name on the check rule is basically using a qualified IRA qualified Medicaid compliant annuity, and we are transferring Joe's qualified account valued at $250,000 into a tax qualified Medicaid compliant annuity by either a trustee to trustee transfer or a 60-day rollover to fund the Medicaid compliant contract. In order to avoid tax consequences, Joe must be the annuity owner. It must be a like-to-like transaction where Joe is the owner of the Medicaid compliant annuity, and by purchasing the annuity with $250,000 over Joe's Medicaid life expectancy of 113 months, we see that the monthly payment from the annuity is $2,300 and the total payout is $259,900. The total payout is just going to be slightly more than what was invested into the contract, and we got the 113 months of the annuity based on Joe's Medicaid life expectancy. He is currently 78 years of age, and with his life expectancy being 9.43 years, the number of months that we could structure this annuity for would be 113 months. In order to use name on the check rule in this case, if Joe is the owner of the Medicaid compliant annuity, we would direct the payments to Mary as the payee. And this is where really the rule comes into play. because we would direct on the annuity application that we want Mary's name to appear on each one of the MCA payments as the insurance company makes those payments. So the only real difference between option number 3 and option number 4 that we were talking about is whose name is going to appear on the check each month. We could simply convert the qualified account into an income stream, and Joe could be the owner, annuitant, and the payee, and that would be considered Joe's monthly income. Or we can direct the payments to be made to Mary as the community spouse, and we can have her name appear on each one of the checks from the insurance company. In either one of these scenarios, option 3 or 4, Mary can be named as the primary death beneficiary of the Medicaid compliant annuity before the state Medicaid agency. So this is something to keep in mind, because if Joe were to predecease the term of the annuity contract, Mary as the primary beneficiary would have the right to roll over the remaining amount into an IRA that's owned by Mary, or she could just continue to receive the monthly payments as scheduled. The impact of using name on the check rule, we were able to keep around $100,000 of assets in Mary's name. If you recall, the couple had $350,000. We annuitized $250,000 of Joe's qualified account, and that means that Mary was left with $100,000 of liquid resources that she can plan with or she can use to live off of. Mary has monthly income of $3,100, and this is determined by taking her Social Security income of $800 and adding the Medicaid annuity payment of $2,300 each month, so that Joe's copay to the nursing home equals all of his Social Security income at $1,500, less his $50 personal needs allowance, and his copay each month to the facility is going to be $1,450. Joe's copay to the facility was determined by looking at what Mary's total monthly income is, and we know that the annuity payment was $2,300. Her income each month from Social Security was $800, so that her total income is $3,100. This amount exceeds what Mary's monthly maintenance needs allowance is at $2,114. So we see that Mary does not have a shortfall each month. So she is not going to receive any of Joe's monthly income under the monthly maintenance needs allowance calculation or the shifting of income. So Joe's copay to the facility is going to equal his $1,500 that he has from Social Security, less his $50 personal needs allowance. And we see that his copay is going to be $1,450 each month. The advantages of using name on the check rule, we were able to obtain immediate Medicaid eligibility for Joe. We accomplished the transaction very quickly. Using name on the check rule or converting a qualified account into an income stream can happen very quickly, usually within a week or two of initiating the transaction. So that is an advantage of using this planning technique, is that it is something that can occur quickly when we're trying to achieve Medicaid eligibility very quickly as well. Mary has monthly income of $3,100 to meet her needs by directing the payments to her as the payee. The couple is going to pay very limited federal income taxes because we're stretching out the term of the annuity over 113 months, as opposed to simply liquidating the account and paying all of the taxes in 1 year. With their taxable income being very low, their Social Security income is not going to become taxable in this case. And if Joe predeceases the annuity term, Mary is going to be the primary death beneficiary of the contract. The potential disadvantages of using name on the check rule is that Joe is obviously going to have a copay amount for his care at $1,450 per month. But the bigger risk in using name on the check rule is the fact that it is not a rule that is backed up or justified under the IRS rules or the IRS regulations. So if your local Medicaid office would challenge name on the check rule by converting a qualified account that's owned by the person in the facility and directing the payments to the community spouse, we really don't have any IRS rules that are going to support that. And it's been our experience that more and more states are starting to challenge name on the check rule and are starting to count the income to belong to the person that is in the facility. And now the fifth option that we're going to talk about is InMarriage QDRO, and I'm going to turn things over to Stephanie. I'm going to continue to monitor the slides here. So Stephanie, if you need me to advance, feel free to just let me know that.
Thanks so much, Amber. Thank you, everyone, for attending. Amber's right. What we're looking at here is a consideration of these assets that we often consider untouchable or even troublesome assets. And on the next slide, Amber will show you a picture of a gentleman with his hands behind his back. And the truth is that's really where I was. I am an estate planning attorney in Louisiana, where at the very beginning, the IRAs are considered countable assets of the institutionalized spouse, and Louisiana is beginning to challenge the name on the check rule. So when I have clients come to me and they have these large qualified assets, it's always very troublesome because we can do so many great things to help protect assets, except for these. We have to look at tax consequences. We have to look at, is it even viable to cash them out? Can we use the name on the check rule? What are our options? And usually those options are fraught with issues. And I had a case just like this where I was able to protect, property and non-qualified assets. And even though my clients were prepared for what would happen with their qualified assets, I still didn't feel good, even though we got them qualified. It just, your hands were tied, and I was so frustrated. And at that moment, I actually was having lunch with a gentleman who would later become my business partner, but I'm having lunch listening to him talk to someone in the booth behind me about this tool that he has utilized in transferring ERISA-based qualified assets to a spouse without someone having to get a divorce or having to be separated. And it was so compelling to me that I actually stopped what I was doing, stood up and introduced myself and said, I have to visit with you. I have to know what you're talking about. And from there, we've developed a partnership. And what he had created is the InMarriage QDRO, which, as on the next slide shows, that these are ERISA-based retirement benefits. And I'll give you a pause here. We're going to start very generally with what is ERISA and ERISA-based retirement benefits. And bear with me, because for most of you, I would think that the biggest assets you're looking at are IRAs. IRAs are not based on ERISA, but I'm going to get you there. But in order to get there, we have to start at the beginning. And the beginning is ERISA. And the type of ERISA plans that we're most aware of are your 401k plans, 401a, 403b, your pension plans, profit sharing plans, deferred compensation, or employee stock ownership plans. So these are the things that we know about. So what does that mean? If we have to work with an ERISA-based retirement plan, well, what is a QDRO? And more particularly, what is an InMarriage QDRO? Well, a QDRO is, if you break it down by each of its pieces, it is a domestic relations order that is signed by an appropriate state court judge. And that domestic relations order, just take note, we have to go to court. It is something that we have to petition the court to provide to us and ask the court to sign. So there is a judicial process here. And that order says some very specific things. It, one, recognizes that there is a joint marital ownership interest in a retirement plan. And then number two, it provides for the transfer or division of those plan benefits between the parties. And the parties have very specific titles. You have the employee spouse, that is the plan participant, and you have a spouse or a person that is entitled under the law to receive those benefits. That person is called the alternate payee. So that order recognizes and then provides for a division of those benefits between the appropriate parties, and then it is submitted to the retirement plan administrator, who then approves or qualifies of the order. On the next slide, a QDRO was created as an exception to ERISA. So if you want to be bored to death or have a headache, go read ERISA, which was created in 1974. And it was originally contemplated to protect the plan participant's interest in his or her retirement plan, and then also to provide the structure to the corporate entities that would provide the retirement plan. In 1974, the divorce revolution had not begun. So we were getting close, but not quite there. So in its original draft, ERISA did not contemplate the division of retirement assets between spouses, which means that you had a lot of conflicting opinions across the country on how to divide or transfer retirement benefits. It only took Congress 10 years to address the problem, and in 1984, Congress amended ERISA to provide for the QDRO exception. And because it is written as an exception to ERISA, means every single word used in the statute matters as much as every single word not used. We have to have a very plain and literal interpretation of the QDRO exception, and we cannot read words into the statute. So when we think about it in those terms, most people would tell you QDRO means divorce. And I would tell you that it depends on who you ask. So if you ask Google, as I did here, Google would tell you QDRO is synonymous with divorce. Honestly, if you ask Wikipedia, and I have had lawyers do that, much to my shock, Wikipedia would also tell you that QDRO is synonymous with divorce. And then you have a lot of professionals, whether they are CPAs or attorneys or other specialists, many of them would also tell you that QDRO means divorce. But what really matters is, what does the law say? And to find the answer to that, we have to determine who is an alternate payee. Recall, I said an alternate payee is the person that Congress said could receive retirement benefits from a plan participant. And if you look at ERISA, it defines an alternate payee as any spouse, comma, former spouse, comma, child or other dependent. Let me stop and tell you, we're not going to address child or other dependent in this presentation. That is restricted solely to if you have a support order for that child or other dependent. But if we back up and look at the terms spouse or former spouse, ERISA contemplated spouses, which in its plain meaning means the person to whom you are married, and former spouses, which in its plain meaning means the person to whom you were previously married, as being an alternate payee. But they provide a very specific provision saying that either a spouse or a former spouse who is recognized by a domestic relations order as having a right to receive the benefits payable under the plan. So we have to have that domestic relations order that, as we said earlier, acknowledges that there is a joint ownership interest and provides for that division or transfer of those benefits. And here we are allowed to transfer to a spouse. And that is again echoed in the U.S. tax code. And I will tell you here, I've had a lot of professionals, rightfully so, say, well, wait, Stephanie, spouse means, and what Congress intended for spouse to mean, is the person to whom you may be married, but you are intending to get divorced, or you've started that divorce process, or the person to whom you are separated, you just don't have that judgment of divorce yet. And I really, really appreciate that perspective. So if we take it a step further and on the next spouse, go to the Department of Labor. That is the federal entity that oversees and interprets ERISA. So before we technically go to the court for an interpretation of ERISA, we actually go to the DOL and say, how do you interpret this provision? What does it mean? And the Department of Labor has already answered this question as to whether or not a domestic relations order has to be issued as part of a divorce proceeding. And its answer is an unequivocal no. A domestic relations order that recognizes marital property rights may be a QDRO without regard to the existence of a divorce proceeding. And I like that terminology, divorce proceeding, because it's such a broad term here. It contemplates every part or every process of a divorce, whether you've separated, whether you filed, whether you have your judgment. And notice here that it says that you may have that domestic relations order so long as it recognizes marital property rights without regard to the existence of that type of proceeding. It next says that it has to be issued pursuant to a state domestic relations law. This is very important. That domestic relations order has to follow the statutory authority granted by your particular state as to how spouses or divorcing spouses, if you're having a divorce, but it has to follow the statutory law that creates or recognizes rights in your state. And every state is different. Every state has different provisions as to what spouses may do. But it is important to recognize that you may seek a QDRO between married spouses without having to have a separation or a divorce proceeding. On the next page. So what does this mean for us? Well, it means that this tool that we previously limited to divorcing parties actually has an application to married couples. And more particularly, what does it mean to us when we're looking at long-term care planning? Well, the basis is that you can move retirement accounts between married couples, but what happens when we have IRAs? Because most of us, when we're looking at long-term care planning, our clients have come to us not with a 401k or a 403b, but rather money that they have already moved into an IRA. So IRAs are different than 401ks or 403bs in that they are governed by a separate law. It is an individual retirement account that usually is receiving your ERISA-based retirement funds, and it's governed by a law that particularly states in order to divide or transfer IRA funds, it must be pursuant or incident to a divorce. So unlike ERISA-based plans, an IRA can only be divided or separated if you are actually in a divorce proceeding. So what do we do with this? So if we move to the next slide. And this is just very generalized information regarding IRAs, and I'm skipping over it because Amber did such a good job of just providing us with that information already. So here we know that we have to divide an IRA incident to a divorce. So our hands are tied again, right? And the answer is No, maybe we just need to think differently. So what if we did this? You have a client that can create an LLC. That LLC may have a solo 401k. I note that an LLC can be created for any reasonable purpose under the law, and as long as you have an LLC, that LLC may have a solo 401k. Once that solo 401k is created, you may then transfer the IRA funds to the solo 401k. Notice that we have just moved from the laws governing IRAs to the terms of ERISA because the solo 401k is governed by ERISA. Now that we have transferred the funds from an IRA to the solo 401k, we have put ourselves in a position where we can do an in-marriage QDRO to transfer those funds to a spouse without a divorce. And before we move to the next slide, we have an example and I'll walk you through it, but I really want to emphasize here that this is not something we should implement in a crisis because it takes time. It takes time to create the LLC, not much time, but still. You then have to create the solo 401k and then move the funds. And an in-marriage QDRO alone takes between 75 to 90 days. Sometimes it's a value proposition for the client to say we're willing to private pay to go through this process, but I'm very, very cognizant of the fact that this is good pre-planning. So when your clients come in and you talk to them, really pay attention to where they are because using this is not a great crisis tool. Nevertheless, let's go through an example here. So we have Mary that's approached counsel to discuss her husband's impending placement in a nursing home. He has dementia. She's been told that they're going to have to spend everything that they own and that they would have to go down to about, just a few $1,000s in order for her husband to qualify for Medicaid long-term care. As we go through the information she provides, we learn that she has property, that they have cash assets, and that there is a retirement and prepaid funeral plans. Now, it's very easy to consider what we can do with the property, very easy to handle non-qualified funds to protect them. But what we really have is an IRA that we're concerned about, and what are we going to do with it? So on the next slide. So let's talk about this IRA. Is there anything that we can do? And the answer is yes. We can use the power of attorney that was created for Joe, where he named his wife as his agent. She then creates an LLC. And note that the LLC is in Joe's name because if we're going to create a solo 401k, the company has to be in his name, so does the solo 401k. So we create the company, we create the solo 401k, we move his IRA funds to the solo 401k. So now we are governed by ERISA. And after we've gone through that process, we may now do an in-marriage QDRO to transfer those funds to his wife. And I note here that all of this was done by a power of attorney. In fact, my very first in-marriage QDRO case was almost this exact scenario where we used a power of attorney all the way through, and it was approved at every level. On the next slide. So what are the benefits of transferring the IRA this way? Well, in some states, the community spouse's IRA is not a countable resource. So if you're in one of those states where you can move it to the community spouse, then you're able to protect it. You can create an income stream in a way that could not be challenged by Medicaid. So earlier, Amber talked about, using the name on the check rule where the asset is still owned by the institutionalized spouse, but you're having the payment made to the community spouse to protect that income. So in many states, as she stated, they're starting to challenge that. But if we utilize the InMarriage QDRO to move the asset to the name of the community spouse, there is no longer anything to challenge, because now the community spouse is the owner of the asset as well as the income beneficiary of that asset. And then, depending on how the income stream is structured, we may be able to avoid income taxes on the distribution. And in my example, and I've done this in several cases, where we had a spouse who received the retirement benefits so that we could generate the income because the income was not counted in my state. And the spouse who was receiving it did not actually need that extra income. So we actually had annual payments over a course of years. And every year when that payment was made, the spouse would then do a 60-day rollover to go drop it back into a retirement account. So we were able to protect all of the funds and avoid the income taxes because they didn't need the income stream. That doesn't work every time. It depends on your facts. So how can we help from here? Well, we'll be pleased to answer any questions if they're submitted. And then also, anyone's able to email or call if you have specific questions about this. But I would note that this is truly a game changer for long-term care planning, especially on those assets that we consider troublesome or are just almost lost for tax purposes. We now have an option to at least consider for protecting them.
Okay, so we looked at whether option number 4, name on the check rule, or option number 5, InMarriage QDRO, makes more sense, and it really depends on the case facts and the type of scenario that we're dealing with. So some items to take into consideration when we're looking at either name on the check or InMarriage QDRO would be whether your state allows only one of the strategies or both strategies. Another thing to take into consideration would be the timing involved in seeking Medicaid eligibility. So as we talked about, name on the check rule can be accomplished very quickly, whereas InMarriage QDRO is going to take a longer period of time. So if we are trying to get something done quickly, then name on the check rule may be a better approach, but InMarriage QDRO is going to be safer if we do have the time to put that into place instead of name on the check rule. Also, I would be taking into consideration the size of the qualified account. If we're dealing with a very large qualified account, say $500,000 or $1 million, we don't want that to be a test case where we're generating a large amount of monthly income that could potentially be going to the institutionalized spouse's care and put them over what the income limitation would be. So I would also be taking into consideration the size of the qualified account when I'm looking at one strategy versus the other. And Stephanie, I'll let you kind of explain this next slide as far as where we know that InMarriage QDRO works and kind of the color scheme on this slide here, if you don't mind.
So we do InMarriage QDROs across the country, though there are a number of states, if they are in red, there are a number of states where we simply cannot do an InMarriage QDRO, and that is based on the state domestic relations law. So earlier I said that your domestic relations order has to be based on your state's laws. There are a number of states that do not allow for contracts between spouses, or if they do, the rights are very, very limited to the point that we just feel it would not be advisable to proceed with an InMarriage QDRO. In all of the dark blue states, those are the states where we have done them successfully. And hopefully we'll have more dark blue states soon. But in each of these states, we absolutely can do it InMarriage QDRO. The law is very, very favorable. The states where they are light blue, we actually can do in-marriage QDROs in those states. There's a note there that we are looking for local counsel in each of those states, because even though I can do them across the country, of course, we have to have local counsel work with us on these cases because we are not licensed in every single state. So the light blue states denote states where we can do the work. We simply need to have local counsel.
Okay, perfect. And now we do have some questions. A lot of these are for you, Stephanie. And so we have about 10 minutes remaining before 1 o'clock. And so it does look like some people were having issues with the audio in the beginning of the webinar. I can certainly send a copy of the recording to you afterwards. If you're still having that issue, just know that I can send you a copy of the recording. But there are some questions here. Let me get back to that. One question for you, Stephanie, is have you had a judge say that moving all the assets from the spouse that needs the care is something that he or she will not approve as a matter of principle?
No, I have not been turned down at all on those regards. In fact, I've been successful in every one that we've tried. We have had two instances of a plan administrator. In other words, the judge had signed my order. We submitted the order to the plan administrator, and the plan administrator came back and said, "Wait, you have to be based on statutory ground here." And in the two cases where they came back, we were using jurisprudence or case law to support the contract between the spouses, and we were able to go back and amend and reference the statute which we were relying and be successful.
Okay. Another question is the ERISA rules states that the spouse who is recognized by a domestic relations order as having a right to receive, how do you get that order?
So what we do is we have to begin with a contract or an agreement between the spouses, and this is where your state domestic relations law are so fundamentally important. The spouses have to do something to create that right between the two of them. So I'll use Louisiana as an example. In Louisiana, spouses can contract to make a gift. Spouses can do a property settlement. We can do a postnuptial agreement. In some states, you can do a management agreement. In Texas, believe it or not, you can do a power of attorney, and that constitutes a domestic relations agreement. So every state is different. We have to pay attention to what each state allows. But as long as the spouses enter into an agreement that affects their marital property rights as it relates to that particular retirement account, then it is sustainable. Now, we're very cautious in pointing out that this is a property agreement. So you want to pay attention not only to what the rights your spouses have, but also what are the consequences. Because if you have spouses that were contemplating divorce last year and now seeking to do an in-marriage QDRO, I may not want to do a gift, certainly not in Louisiana, because if you make a gift here, then that becomes a separate property of the spouse who received it. But the rules are different in other states. So we always pay attention to not only the rights, but the consequences and how do they apply to your particular client or family.
Okay, another question is, are there some examples of how the in-marriage QDRO is structured? Is this something that for which we would need to associate counsel experience with these types of proceedings?
So that's a great question. And the answer is you can try to do it on your own. It's certainly, we're not hiding the ball on anything here. What we have found that has been very successful is we've done them across the country with great success. And we've had lawyers come to us and say, I have a client, or I have, a potential client, this may work. And the lawyers would have us act as basically their back office or their consultant, meaning that we would prepare all of the documents, we would make sure that they fit their circumstances, and we would submit them to the acting attorney to review with the client, to sign and to file. But we were there with them through the entire process to make sure that it was successful. In other cases, we've had clients come directly to us, and if they engaged us, they gave us permission to have local counsel, and we would immediately go out and secure local counsel and be a part of the process all the way through. So it depends on what is your preference, what is your comfort zone, but it would be a pleasure to work with you.
Okay, perfect. Can you speak to a cost range of doing InMarriage QDRO?
Yes, absolutely. So if a client comes to me directly, we charge a flat fee of $7,500, and that flat fee covers not only my cost in doing the work, but would also cover what I would pay local counsel for their services. However, if an attorney is coming to me to say, I need your help to do consulting work, I would charge the attorney a flat fee of $2,500 and walk them through the entire process. So it's a little bit different depending on who's approaching me for assistance, but it's always a flat fee.
Okay. Another question is, how would you structure the LLC from a tax standpoint? Have you gotten any pushback from the IRS on these?
No pushback whatsoever. None. We've done them successfully.
Okay. Another question is, in a pre-planning case, I never know who the IS will be. So how would InMarriage QDRO be used? I might transfer it to the wrong spouse and then all of the funds would be in the IS's name at that critical moment.
So that's a great point and an excellent question, because what you're doing is, you can't, obviously we don't have the crystal ball. If we did, wow. So in my cases, I've had clients who came in and we just paid attention to what we could. So if you have a family history of dementia, then maybe we consider, at least starting the process to move money to a solo 401k, especially if it's in an IRA. Or if we've come in and somebody says, look, I've gotten an early diagnosis, we're going to try to keep me home for years, but we want to start getting our ducks in a row now to protect what we can. Well, that's an easy one. But I would note that even if you didn't know who was going to get sick, if you're dealing with an IRA, then the idea is to just move it to the solo 401k. It's still in the name of the original owner, but if it's now in the solo 401k, then if you need to do an InMarriage QDRO down the road, then you can. You've saved yourself some time in some of the process. You don't actually have to do the InMarriage QDRO until it's time, because I don't want you moving money willy-nilly without having a sound basis for knowing why we're moving it. But you can save yourself some time to at least get it in the solo 401k and then sit on it and say, we'll move it if we need to later.
Okay, perfect. Can you speak to, Stephanie, I know in another webinar that we've done before, you talked about transferring income streams like pensions from one spouse to another. If you have a case where one spouse has a very large pension and they're the institutionalized person, can you kind of talk to that a little bit?
Absolutely. In fact, it is one of the first cases that I did with an InMarriage QDRO. In fact, it was the case that was bothering me when I first met my partner, Marcus Foote. I had a client that we were able to protect almost everything except for the institutionalized spouse's pension payment, and there's nothing I could do, at least at that time. My client had approached me years before to do their estate plan, so we had good powers of attorney, we had a good trust in place, and assets protected. We knew that there were going to be some changes in health, and then when the community spouse contacts me and says, look, my spouse is going into the nursing home, I know we've protected everything, we just need to make sure my ducks in a row, we need to do the Medicaid application. What are we going to do? And in this case, we got the spouse qualified for Medicaid, but at the loss of this pension because the community spouse was, I kid you not, $20 over the triple M&A. So we could not take any of the institutionalized spouse's funds and transfer it to the community spouse. So and it didn't matter that the community spouse needed that money. There was nothing I could do to protect it. And after I learned about the InMarriage QDRO, we actually used the institutionalized spouse's power of attorney to give the pension to the community spouse. We had a gift document signed because the power of attorney allowed for self-dealing. The community spouse was able to give as agent for the institutionalized spouse the pension, and we asked the court to sign a domestic relations order recognizing and enforcing that gift, which was then submitted to the plan administrator who transferred that pension to the community spouse. We saved that family, I want to say about $25,000 to $27,000 a year just in income by using an InMarriage QDRO to transfer that pension to the community spouse. It was beautiful planning.
Awesome. Okay, so everybody that's on the call, yet you're seeing both of our contact information, mine and Stephanie's. Feel free to reach out to us with questions. There are more state-specific questions that we weren't able to get to based on time, but I will reach out to you individually to answer your questions. But feel free, if you have questions related to InMarriage QDRO, to reach out to Stephanie at the phone number that you're seeing on the screen, or if you have questions related to name on the check rule, you can reach out to me, to Amber, and my email and phone number is on the screen. Again, I want to thank everybody for joining us today. I hope that everybody stays well, and we will talk to you soon. Thank you, Stephanie.
Great. Thank you so much, Amber.